applications in the matter of Depp 2 and the News Group Newspapers Limited and another.
Yes, Mr. Caldecott, just before we start, this hearing is being live streamed. Can I just draw the attention of those watching to the message which they will see in the bottom half of the screen, which means that the live stream footage should not be recorded by audio or video or still photos made of it. Still less should anything be retransmitted on social media or in any other way. That applies to anyone viewing. Of course, that does not prevent ordinary reporting by journalists and others watching in the usual way. Yes, Mr. Caldecott.
My Lord, on these applications, I appear with Mr. David Sherburn and Ms. Kate Wilson for the applicant, Mr. Depp. My learned friends, Ms. Sasha Wass, Mr. Adam Wolanski, and Ms. Clara Hamer appear for the respondents, News Group Newspapers, the publishers of the Sun newspaper, and a journalist, Mr. Wooden, who is the author of the article complained. Lord, there's a privacy order in place, which I thought I should just mention. It's already been made, and I just mention it so the media can obtain copies. I hope it's outside court on display, but if anybody wants to see it, they obviously can.
Yes. In fact, it doesn't apply to anything, I think, that you're intending to say.
Correct, my Lord.
But it does explain why certain documents that might otherwise be available are not.
Yes, it also, my Lord, would explain why, if any of the media ask anybody what we were referring to, it would be wrong to say.
Yes.
That's the only point that really matters.
Well, I certainly reinforce that. Copies of the order are available and should be consulted by anyone who's in any doubt.
Yep. Lord, thank you. Lord, can I state the background very briefly, because everybody is aware of it?
Yes, can we just get a feel for the timing? Have you spoken to Ms. Wass about this? Or?
My Lord, no, because your Lordship's direction rather implied that the court would be flexible about it and would take a view. I'm certainly aiming to leave a little time at the end for the other side to have their say.
Yes.
I can't honestly be sure, because I anticipate there will be some questions in this quite difficult
Well, of
case.
course, we will be flexible, but with a view to the estimate, which is 2 hours. The formal position, I think I didn't quite accurately state in the order. On the further evidence application, the respondent has a right to respond.
Lord, yes.
On the permission to appeal application, as you don't need telling, there is no automatic right for the respondent to respond, but the court may want their help on certain points, and we'll want enough time left to see what we need help on.
Yes.
I think if you could aim to have completed your submissions in something like an hour and a half,
Lord,
we'll then take stock, but that will leave time for Ms. Wass, and as I've been told, Mr. Wolanski as well, to make any submissions that we require from them.
Lord,
thank you.
Lord, Mr. Depp brought this libel action against the respondents in relation to an article published on the 27th of April 2018. Its meaning is set out at paragraph 80 of the judge's judgment. Just to give your Lordships the reference, it's bundle A, orange, tab 5, page 74. The action was tried over 16
I'm sorry, Mr. Caldecott, one more thing and then I will let you get on. I should say, of course, I quite understand that you want briefly to open this, and that's understood. But we both found your note extremely helpful.
Well, I'm grateful.
We have pre-read everything that you specifically referred to there, plus a bit more. We have also listened to the piece of audio that you wished us to listen to. So, as I say, I'm sure you want to open it, and that's entirely reasonable. But you can take it we're very familiar with the background and have done a lot of pre-reading.
Yes, for the benefit of those watching.
Of course, but I just wanted to say that.
Lord, that's very helpful. The judge found for the respondents on their plea of truth under section 2 of the 14 pleaded incidents of violence, all but 2 were found to be made out. The ones that weren't were incidents 6 and 11. Of the 2 pleaded incidents in the confidential judgment, 1 was rejected and 1 was found to be true. And following the verdict, Mr Depp issued the two applications. The first in time was for permission to appeal. Then, as a result of documents becoming available through some subpoenas in the United States and through Ms Heard's own disclosure in the Virginia defamation action, later in January, the application for permission to produce fresh evidence. Well, I propose to follow my reading list, if I may, in terms of the order,
Yes.
and deal with the fresh evidence first. And Lord, I do need your Lordship's permission to add two further witness statements. They are at De Bene Esse, as it were, at tabs 11 and 12 of bundle C. Your Lordship will have noted that there's an apology for this because there was an omission. It's
Yes.
obviously something your Lordship should be aware of.
Let's see. I can't imagine that there is an objection to being referred to them without prejudice to any decision we may ultimately make about their admissibility.
My Lords, Mr Wolanski is going to be dealing with the second part of this application, namely the fresh evidence, and I will let him deal with that. I am going to be dealing with any assistance I can give the court in relation to the permission to appeal.
Very well, thank you. But Mr Wolanski, no need to come forward just to deal with this. There can't be any difficulty about our reading those witness statements. Indeed, we already have. Thank you.
Lord, the legal principles here are very well known. If the Lordships want a convenient place to find them without having to turn to any authorities, pages 1798 to 1799 of the CPR Volume 1 set out the principles. Just to give your Lordships in shorthand, the well-known original Ladden-Marshall test. The first one is reasonable diligence. I'm using shorthand.
Yep.
The second is probable important influence. And the third is apparently credible. As we know, the position now is these are not rules, but they are principles to which the court will still always have regard, but just bearing in mind that the overriding objective is to do justice. There's a case called Turluke and a citation from Hamilton and Al-Faid in those notes on those 2 pages, and I suspect your Lordships are well aware of them, and I'm not going to take up time reading them, but that's where they're to be found. Lord, there is one issue of law between us. I'm going to take our position very briefly. The respondents rely on a case called Braddock, which imposes a very high threshold indeed. But we say that is not the applicable threshold in this case. In Braddock, there was no deception of the court at all. There was a subsequent discovery of historic convictions, in fact of uncertain date, and it solely went to credibility, and there was no deception of the court. We submit that where there has been a deception of the court, which is our case, we say the correct test is the real danger test, which is that which appears in Hamilton and Faid at paragraph 34, and it's in the authorities bundle. There has to be a real danger that it influenced the judge in terms of the outcome, or not merely as to 1 or 2 incidents. Lord, there's one other point I should just mention. Your Lordships will no doubt be aware of the famous case of Meek and Fleming. In most of these cases, though not Braddock, it's the party who's been responsible for the deception. In this case, it's not a party, but we say that the same principle must apply, and indeed the Hamilton test, I think it's paragraph 34, doesn't put it in terms of the party having to be responsible for the deception. It would be a nonsensical description, really, if one's concerned with a just outcome. Here, the key witness for the defendants was Miss Heard. They would have had no defence without Miss Heard. There were many other witnesses, but she was, on any view, centre stage. I'm going to follow, if I may, the order in my reading list.
Yes.
And the first question is the meaning of the evidence which we say was false. Lord, it's quite convenient, just says not to jump around, to keep to the green bundle, which is the fresh evidence bundle for these purposes. If you can kindly go, please, to page 9 of C3. sorry, it's not page 9, beg your pardon. It is page 9, it's C9, I should say, rather than
Yeah.
internal my fault. If you could please just go to Miss Jones' witness statement. She deals with the relevant extract from the witness statement to paragraph 16. As for what Johnny says about my so-called agenda in marrying him, the financial benefit or to somehow further my career, that's preposterous. I remained financially independent from him the whole time we together, and the entire amount of my divorce settlement was donated to charity. In fact, my desire to remain financially independent was one of the main sources of conflict during our relationship. Now, the context has some importance here. The divorce was settled by a joint statement in August 2016, which was a basic part of the background narrative at the trial. And the witness statement from Miss Heard was put in on the 26th of February 2020. The Lordships will recall that there was an original trial date in March, which was later adjourned. There is no reference at all in the witness statement to future intentions or pledges. It means what it says. We say that all 7 million have been given to charity and I have not kept a cent. That is clearly how the judge understood it. If one looks at paragraph 20 on the adjacent page, please, at C10 in tab 3, he deals with the gold digger scenario in the first part of that quote. Then about 6 lines up, he says this: Ms. Heard's evidence that she had given that sum away to charity was not challenged on behalf of Mr. Depp, and the joint statement issued by Mr. Depp and Ms. Heard as part of the deal point memorandum acknowledged that this was her intention. I recognise that there were other elements to the divorce settlement as well, but a donation of the $7 million to charity is hardly the act one would expect of a gold digger. Now, Lord, I'll come back, if I may, to some further messages which we say that conveys. That is the literal meaning. And can I just deal with the literal true position first? There were 2 charities that received money from Ms. Heard: Children's Hospital of Los Angeles and the American Civil Liberties Union. On the 18th of August, this is 2016, Ms. Heard had publicly stated that the $7 million would be equally divided between them. And again, in the same file, if you could kindly go to page C29 in the same tab 3, this is the green file still, you'll see that there's an italicized statement from Ms. Heard. The second paragraph, as reported in the media, the amount received in the divorce was $7 million, and $7 million is being donated. This is over and above any funds that I've given away in the past and will continue to give away in the future. The donation will be divided equally between the ACLU, with a particular focus to stop violence against women, and the Children's Hospital of Los Angeles, where I've worked as a volunteer, and so on. Now, that was issued on August 24th, 2016, shortly after the previous joint statement. Now, the true position as to the hospital...
Sorry, can I just be absolutely clear how these documents fit together? At C27, we have something of August the 18th. I read the text that follows, in fact it's clear the text that follows at C28 is the text that goes with that picture at C27.
Yes.
And indeed the text that follows that is clearly page 3 of 6, so it's clearly the same document. So where do we get the 24th of August from?
Lord, I think it's an error in my note. I think your Lordship's right.
Okay, it doesn't matter. It's
Sorry,
not to
it's
make
my
sure how
fault.
they...
I'm reading down, I think, to the next document. It is the 18th of August.
Yep.
It's my fault. Lord, page 31, I'm dealing, first of all, if I may, with the Children's Hospital, is a donation letter from Mr. White. Can I just explain? Mr. White is an accountant, senior partner in his firm, who is advising Mr. Depp.
Just before we leave the previous document,
Yes.
as I've understood it, for reasons which of course are explained, that document was not before the judge because there was no challenge to her statement that she'd given 7 million. Details of who she gave it to and what exactly she said outside were not before the court. Is that right?
Lord, it's not quite right, but can I just say the position is this. This document was in the trial bundle, but it was not referred to in evidence.
Yeah.
So, and it's fair to say that the judge does not refer to it in his judgment. I was going to come to this later. The judge does not refer to it in his judgment, and we simply do not know whether he read it or not.
It's one of the documents which was asked to be put into the trial bundle
By
your
yes.
team. Yes.
And it's a point the other side make. Lord, yes.
Thank you. So sorry, you were about to
No,
say
not
just
at all, Lord. No,
Mr. White.
It's
Yep.
important to get these matters right. Lord, page 31 is the only donation that was ever made to the Children's Hospital on the evidence. It is a donation made, or sent I should say, by Mr. White, whose position, as I've explained, and he says this donation is being made in accordance with Miss Heard's pledged gift of $3.5 million to Children's Hospital Los Angeles Foundation. This cheque represents the first of multiple scheduled instalments to honour the full amount of Miss Heard's $3.5 million pledged gift. And Lord, that is obviously, as it were, parasitical on the public announcement we've just looked at. Indeed, it's sent only 6 days later. And the instalment point reflects the obvious fact that the payment of the $7 million was to be by instalments. Now, well, the next important letter, and this is an important letter, is at page 42. And this is 3 years...
I'm sorry, can I just ask one other question about C31?
Yes, Lord.
I think I saw, though I haven't, I'm afraid, noted the reference, that Mr. White says he had some discussions with, or a discussion with Ms. Heard, not saying that he would make this payment, because that was contentious once it happened, but nevertheless about certain tax aspects. I can't remember the exact detail. Do we have evidence as to whether he had spoken to Ms. Heard before the letter of the 24th of August?
There's no evidence that I'm aware of any speaking to Ms. Heard, but there was a letter from Ms. Heard's attorneys taking exception.
Oh, but that's afterwards.
Yes, that comes later.
But didn't Mr. White say somewhere that he had had a discussion with Ms. Heard about...
Lord, he says he had a discussion with Mr. Depp's attorneys, and he got no answer, is my recollection.
Well,
Can I help?
I think Ms. West knows what I'm referring
Yes,
to. That would help us.
I do. My Lord may be assisted by the agreed chronology that appears at Bundle A behind Divider 3. And indeed, it would be a hope of assistance to my learned friend to refer to that as well, because the dates...
Well, Ms. West, yes.
At page A48.4, at item 131, my Lord got that.
I have.
That is a passage of a transcript, as my Lord
I'm
knows.
so sorry. I've got the page A48, but I haven't got the particular entry you want us to look at.
A48.4 is where it starts. At the bottom of that page,
Yes, I see.
it's day 5, cross-examination of Ed White by the Defendants' Counsel. And on the top of page 48.5, the answer at the top of that is the question.
Thank you. That is exactly what I had in mind. Mr. Caldecott,
Yes.
his evidence was, therefore, that during that time, I'm not quite clear what that means, I suggested to her she did not need non-taxable income.
Yes.
I don't understand the details, and that doesn't matter, but I'm not... Is is it clear from that that before he made that payment, he had some discussion with her about the taxable, about the correct approach to the payment she said she wanted to make? Rather looks like that.
Lord, what is slightly difficult about this, and I don't want to spend too much time on it, is that there obviously was a disagreement about this, as we know, because her attorneys then write back
quite.
and take exception
So
to it.
we ought to have made it.
So it's a little uncertain whether he's talking about her or her attorneys, or quite...
I don't want to take up your valuable time, but part of the value of this hearing is just to pin down.
Lord, absolutely.
And I think there is a slight uncertainty as to whether this was entirely out of the blue, clearly
Lord, yes,
stated,
yes.
or whether there had been some
Yes.
prior discussion.
Yes, there's a suggestion that there may have been some contact about the tax aspect.
Yes.
Lord, I was just...
Thank you, Ms. West, for that reference.
Yes, thank you. Lord, can we go to, please, to page 42, which I know your lordships will have looked at, it's on the reading list.
Yes.
This is, there are two letters here. There's an earlier letter to Mr. White on the 14th of June on page 41. And this is the letter that Mr. White says never reached him.
Yes.
And I'll have to come back to that when I look at reasonable diligence. But on the question of the true position, this letter is important. I'm following up on the correspondence the Children's Hospital Los Angeles received on August the 26th, 2016, when it was notified by Mr. White and so on. That's a reference back to the letter we just looked at. I'm inquiring if you have knowledge, if the hospital should expect further instalments on your behalf, or if the pledge will not be fulfilled. I appreciate any insights on this matter and can be reached at via direct line and so on. Now, Lord, there are two important points about this letter. First, there is no evidence that it was ever replied to.
And the letter was obtained on the subpoena to CHLA, so one would expect that if there were a reply, it would be on their file and would have been disclosed.
Yes. And also, Lord, there has now been disclosure by Miss Heard in the Virginia proceedings, and no reply has been disclosed.
Right, thank you.
Now, there are a number of points about this. First of all, the only evidence of a pledge which this letter suggests exists is drawn from Mr. White's own letter. There is no reference here to any independent pledge from Miss Heard. And secondly, I just make this point, that it is an entirely understandable letter for a charity to send, and one would reasonably have expected a reply if there was some genuine future commitment to continue to give. And in short, on the evidence as to the Children's Hospital, it appears, from what we can see, that there was no apparent pledge produced by Miss Heard, and the only donation was $100,000, not the $3.5 million, which we say the court was led to believe was the true position.
Do you say that the evidence supports the inference that her appearance on the Roll of Honour donors, got the name right, is also based on Mr. White's letter of
Lord,
16?
We do.
Yes, I see.
We do.
Thank you.
Now, the position is different in relation to the American Civil Liberties Union. It received $350,000 from Ms. Heard, which is, of course, a tenth of $350 million, and again, an additional $100,000 from Mr. White sent on the same day. I don't think we need look at it, but the letter of acknowledgement of receipt of the $350,000 is at page 281 of tab 3. And Mr. White's cheque, again of the 24th of August, is at page 174 of tab 3. Now there is an unsigned pledge, as your lordship would have seen, at page 279. It's not, there's no equivalent document for the Children's Hospital. It's not signed, and it doesn't specify what the instalment payments will be. It merely says they will start on the 19th of August 2016.
You're right that it's not signed, but it is also the case that C281 is a letter from ACLU to Ms. Heard referring to your very generous pledge.
Oh, yes.
So they certainly thought that they had an effective
Lord, yes,
pledge.
absolutely, Lord. The reason I do is that there is this distinction between the Children's Hospital and the ACLU on the evidence. And unlike the Children's Hospital, the ACLU was aware of a pledge, and that appears to be from Miss Heard. It certainly can't be said that it was only from Mr. White with any clarity. So the position in relation to the ACLU is that they received $450,000 as against $3.5 million. Now the next question is the position as to honesty. There is at the moment no evidence before the court from Ms. Heard herself, either directly or indirectly, about this, by which I mean post-trial evidence. The inference from the true position against the reality is the first point we make. The gap is so large.
Sorry, just, you say there's no evidence from her directly, obviously that's the case.
Yes.
Indirectly, have we not got a transcript of what her counsel said?
Oh, yes, your lordship has that, yes.
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 That, as I understand it, is a statement on her behalf that the full payments have not been made.
Yes.
But she says they will be.
Yes.
Yeah.
My lord, second important point on honesty is the timeline. The final divorce instalment was paid on the 1st of February 2018. The third point is her stance in the American subpoena proceedings. And if I could just take your lordship to the chronology that my learned friend helpfully referred to at tab 3, the various steps that she took, and there is in fact one additional one. You'll see at cell 129, the trial finished on the 28th of July, 2020. And we know that as against the Children's Hospital, I'll have to come back to the extension on reasonable diligence if I may, but we know that with the extension, the documents were due on the 29th of July. And the following day, if we look at cell 137, this is right after the conclusion of the trial, on the very day that the documents are due, she files a petition to quash the subpoena. That's cell 137. She appeals the decision against her on the 23rd of November at cell 142. That was dismissed on the 18th of December. That's at cell 146. And we also know now from Ms. Vasquez's witness statement at tab 12 of the Fresh Evidence Green Bundle, at paragraph 38 on page 584, that even then she sought to have the documents designated as confidential, meaning that they could not be used in these proceedings. And Mr. Depp, through his attorneys, had to apply to have them de-designated. Now, there is a further important point which is not quite so obvious. If your lordships would kindly just look at the Children's Hospital subpoena at C3, the same file please, page 207. This is about really the opportunity to correct. At C207, the lordships will see under Certificate of Service, I hereby certify that I caused a true and correct copy of the enclosed subpoena. Can I just pause to say that your lordship will remember subpoenas are issued originally in Virginia, then you have to have a subpoena issued in California to be effective. This is the Virginia one. I caused a true and correct copy of the enclosed subpoena for production to be sent via email on this 29th day of the council, a record signed by Mr. Chu, who is Mr. Depp's attorney. And there's a service list on the right-hand side. I mean, it's obvious Miss Heard did know because she makes her application on the 29th of July. But this is on the 29th of May when the subpoena is issued. And it's counsel, the bottom left column, counsel for the defendant Amber Laura Heard, and this is Mr. Rottenborn. So she knows subpoenas have been issued on the 29th of May. She is in court, and your lordships will have seen, I'm not going to take you to it, there's a reference in closing and there's a reference in judgment. Sometimes, there's no doubt, errors are made in witness statements in haste, and they are corrected, and it's commonplace. But at this stage, as at May the 29th, she can be assumed to have been told this by her attorneys. She knows that subpoenas are being pursued, and that must have focused her mind on the true position, we say, and whether or not that witness statement required revision. And we obviously invite the inference that that step was not taken because it was appreciated how damaging a correction might be. And that does, to some extent, go to my next heading, which is obviously the important one of materiality. I'm going to deal with reasonable diligence last. Now, Lord, the evidence has, we say, two obvious effects which would have been apparent to the judge. The first is, this is a wholly remarkable act of philanthropy, if true. It is a remarkable thing to do. And on any view, it is, if I can put it this way, a considerable boost to her credit as a person. The secondary message, and I accept the judge does not allude to this in terms, but we say it's a potent subliminal message. I want him to pay, but I don't want to keep a dime of his money because of the way I've been treated. And obviously, in the context of this case, it implies revulsion at the way he's treated her physically. Now, your lordship, if I may say so, pertinently put me a third proposition this morning, and I cannot say that the judge was aware of this, which is the third point is that the focus of the ACLU contribution in her public statement was to victims of domestic violence. But I cannot, it would be mere speculation as to whether the judge did or did not read that document. I'm not aware that it was referred to in evidence. There were a huge number of bundles, and I wouldn't be right to try and draw that inference. But this is a very different case from Braddock. Firstly, it's evidence in the case to which the judge refers to in his judgment. Secondly, it creates a very potent starting point when considering the kind of person Miss Heard appears to be. And thirdly, it does go, we say, to some degree, to the likelihood of her being a victim of grave domestic violence. It tips the scales against Mr. Depp from the very beginning. Deal with one argument which is made against me and which I understand, and the argument is this: it only came in as an answer to the gold digging allegation, which was not pursued at the trial. That is correct, but our case in this court is not based on the suggestion that in fact she was a gold digger, but on the very different, but equally, in fact, if anything, more potent message that these are the actions of a very virtuous person and a victim. Now,
so don't take this as a pointed observation, but just for clarity, effectively you are asking for it to go in as to credit.
no, there's a very interesting, every case has its own geography. Some evidence goes solely as to credit. This evidence, we say, doesn't go solely as to credit because of the secondary message I've referred to, that she wanted him to pay but didn't want any of his money because of the way he treated her. Now, of course, there is a third category, which is where the evidence goes directly to the believability on a detailed primary issue, namely, for example, whether he assaulted her in incident 2. I'm not suggesting it's that kind of evidence. But equally, it's not evidence solely as to credit.
So tell me again, just so I can note it down, exactly what you say it goes to, which isn't credit, goes to whether...
It goes to the likely starting point the judge would have taken as to whether she was a likely victim of domestic violence, having given away the entirety of her financial divorce settlement.
Is there any indication in the judgment that the judge took that?
Lord, the words the judge uses are simply this: these are certainly not the actions of a gold digger. But that begs the question, what are they the actions of? One would not expect the judge to go into what he subliminally thought about this, but we say the message is very clear. When he says it's not the actions of a gold digger, it has a quite additional positive force as to the kind of person she is.
If you read that passage in the judgment, perhaps we're going to take us back to it, but it all starts with Mr. Depp's repeated characterization of her as a gold digger, and his theory that he had an insurance policy which he equates with being a gold digger, which, as you say, certainly at one point Mr. Sherborne had disavowed, but the judge thought it might still be live in one form or another.
Yes.
He's certainly not directly dealing with it as going to credit at all, is he? Credit in your, even in your sense?
No. No. But your lordships will know as trial judges, there are commonly potent background material about a person which influence the way in which you consider, is it likely that they were the victim or they were the perpetrator or whatever. And in fairness to the other side didn't put it on that basis, I also accept. But that's not the point. it's the tilting of the scales from the outset. It's a false plus to her, and it's a false minus to him, if I can put it that way.
Yes. Can you just help me on one point of actually how the point was deployed? I've seen several references to Mr. Depp having made this point in his evidence, and indeed in things he said in texts and so forth. I've read the passage to which we referred, in which Mr. Sherborne disavowed that as part of the case. But it slightly reads, or one gets the impression from paragraph 577, that Mr. Sherborne might, I don't mean this rudely, but might have gone back on that a little, and that it might have formed part of the closing submissions. But we haven't, I think, got to that passage of the closing submissions, or if we have, I overlooked it. It may not matter very much, but because we're in focus on this paragraph, it would be quite useful to know why the judge was addressing it. Are you in a position to tell me? Or
My Lord, I've obviously have explored this. I will ask Mr. Sherborne again, but my understanding is that he didn't pursue Golddigger at all in closing.
Yeah, okay.
Well, can I just make one other point while we're on this? Miss Heard had a perfectly valid answer in her witness statement to this allegation, which was the statement almost immediately preceding the one we complain of, where she said, I always insisted on being financially independent. She says that in the witness statement in the very same passage. She had no need to put this in at all. She had a perfectly good answer. Now, Lord, to assist on reasonable diligence, I've divided them up into different points, groups of points, so that's a slightly more easy way of looking at it. The first group of points made against me all relate to Mr. White, whom I've already introduced. It said that he knew that Miss Heard's donation to the hospital was to be paid in instalments by reason of the letter from him of the 24th of August. That's true, but it's just after the divorce has been announced, and it merely reflects the fact that the payment was going to be made in instalments by Mr. Depp to Miss Heard. It doesn't take us any further on the issue. The second is a reference to Mr. White's cross-examination, just to give your lordships a reference, at tab 4, page 348, internal transcript, top right, page 811. He in fact gave some evidence about incident 13 because he was at the dinner party. It said that Mr. White didn't ask the charities, and he could have done. He explains why he doesn't in paragraph 7 of his third witness statement at tab 8, page 565 of the same bundle. And as to the other inquiries, he deals with those in the same witness statement. He says they were made of the US attorneys and they didn't have any information. Respondents also point to the letter at page 41, dated the 14th of June 2019, which very briefly looked at, and Mr. White confirms that this letter didn't get through to him. See paragraph 8 of his third witness statement, tab 8, page 565.
Yes. You probably can't see that any further. It's a bit surprising.
Lord, can I just...
The letter to him apparently at his office.
Yes. Can I advance some reasons why it does seem to be the likely result? Firstly, there's no reply from Mr. White, as you certainly expect if he had received it. Secondly, the letter never got through to the applicant's US attorneys, and you'd have expected Mr. White to have forwarded it if he had received it, bearing in mind that the Virginia defamation action had begun in March before this letter was received. And those two, we say, support the probability.
Yes.
I'm sorry, your lordship's quite right. I mean, one instantly says what one usually does receive one's post. But there it is. Yeah. The next group of points, so those are the Mr. White group of points. The next group of points are taken on alleged inaction before the trial. Firstly, it said it's not included in the application made against Miss disclosure in this action? Well, there's a very short answer to that. Firstly, the application which was made was rejected in its entirety. And secondly, there was no prospect whatever of satisfying the very stringent rules in 3117, subparagraph 3A of the CPR at page 1033. Because if you're applying against a third party, as the court will know, you have to show it's likely to either damage the case or advance the case, the usual disclosure rule. If you've got no evidence to show that it's likely and it's simply a speculative application, you don't get over the basic hurdle. The second point made about pre-trial conduct is that we didn't seek to adjourn the trial, have the evidence produced. Your Lordships, if we could just please just quickly go back to the chronology for these purposes at tab 3. Your Lordships will see from cell 104 that the trial was originally scheduled to start on the 23rd of March and to run to the 3rd of April, and it was adjourned on the 20th of March, and by now, of course, we're into full COVID. A lockdown was at the very beginning of that month. The defendants opposed that first application to adjourn, and they said in open court, which was widely reported, that Mr Depp was running scared and would never turn up. It's wholly fanciful to suppose that the court would have granted a second adjournment of a trial, and those of us who deal with these adjournments regularly know the courts, and my Lord Justice Dingemans will certainly know this, the courts are very reluctant to adjourn trial dates, and particularly second trial dates. Now, the third point, which I accept requires closer consideration, is the true suggestion that the US subpoenas could have been issued earlier. Now, we say that the dates nonetheless require scrutiny, because the question is whether we could have obtained the evidence with reasonable diligence. Cell 88, just to remind us, is that this becomes evidence in the case on the 26th of February 2020. It's when the third witness statement is put in, and that obviously raises the profile of the issue. I just don't ask your Lordship to go through them now, but you'll see from cells 89 to 111 that there is an enormous amount of interlocutory activity going on in the case, all the kind of skirmishing with which I'm afraid these cases tend to have as they come close to trial. COVID intervenes. I think lockdown was the 20th of March. 23rd of March, I'm sorry. We, of course, now are living an experience at the other end of the tunnel, or not quite at the end of it, but getting to the end of it. But it's very easy to forget the complete disruption that the COVID lockdown had. And of course, we know, for example, the ACLU closed its offices, which caused considerable problems for service. The subpoenas were in fact issued on the 29th of May. That's cell 112. Now, the Children's Hospital request for an extension, which of course is something that I have to deal with. This reference. Lordships will
we needn't.
Yeah,
it's clear that they did make a request.
Yes, and my Lord, the important point is, this is a children's hospital. The letter is sent on the 26th of June. It doesn't actually get through until the 29th, which is over a weekend, And the real point about it is that they expressly refer to staffing problems at the hospital as a result of COVID. And the evidence, and I'm not going to go, I may not go to it in detail because of time, but the evidence is that the extension, refusing the extension would have just brought trouble.
Well, we've read that evidence.
Well, I'm grateful.
Myself, I can understand it.
Yeah. Now, what is revealing is that even with the Children's Hospital, it took many months to resolve Miss Heard's opposition. And this is obviously a very important causative element. The last group, we say, this is not a counsel of perfection. I accept the subpoenas could have been issued earlier, but we say causatively, the probability is that they wouldn't have produced anything in time. The last group relates to the applicant's position at trial. First of all, a witness called Christina Sexton, who's important on a quite different point, was called by the defendant and asked questions about the donations when she was deposed in the US. But that subject was not pursued with her at the trial of this action. I'm going to just give your lordships a reference, if I may. The simple reason is that Miss Sexton's answers during the US deposition make it absolutely clear that she had no useful evidence to give on the topic. The reference is page 373, internal transcript, page 153. The next question, or point rather, that's put against us is that Miss Heard was not cross-examined on the issue. Now, it's perfectly true that there was a general view that she was untrustworthy and there was scepticism about this claim, but there was no evidence to gainsay her evidence. And we say it was a perfectly reasonable decision not to cross-examine on them in those circumstances.
Would have been perfectly possible to ask a neutral question along the lines of to whom has the money been donated, what sums were paid when?
Yes.
And we don't know what answer. Well, we know now what a truthful answer would have had to be.
Yes.
But she was not given the opportunity to say, as she might have done, well, I've only paid some comparatively small sum so far, but I've made a pledge to both, and I'll be paying it over X years. We just don't know what she would have said.
But even supposing hypothetically a question had been asked, it would not have produced these documents. You can't properly ask.
No, but if she'd answered that, you wouldn't have needed the documents. That would have shown what the documents you've had so far have in fact established.
Well, Lord, the documents, example, we say that the letter from the Children's Hospital has a far wider significance than that. It suggests there was no pledge at all, and just the original $100,000. I mean, we said, firstly, that if you're talking about reasonable diligence, it's a perfectly reasonable decision by an advocate to make, not to challenge a clear statement. And it is a clear statement that she had donated it all. There was nothing, no evidence to suggest she had not. I can't dispute your lordship's proposition that a neutral question could have been asked. But with respect, there's no real reason to assume that it would have produced what we now have.
But it's a point you're perhaps going to come to. Clearly, that was at least in contemplation, because documents that would have laid behind such a question were included in the bundle at your request.
Well, the documents were put in the bundle. The subpoenas were outstanding. The subpoenas were not effective in time for the trial for the reasons we've looked at. Your lordship is quite right that there was a decision to put those documents in, They do have a potential bearing on one or two other issues, potentially, particularly the role of the publicist. But Your Lordship is right. And I think it's accepted that there were suspicions about the claim. And Miss Hurd was viewed as untrustworthy, and Mr. Depp was sceptical about it, but he had no evidence. And my Lord, it is taking a number of speculative steps to assume that even a neutral question, had it been something we should have done, which is what it really has to be, even if that hurdle is got over, it's very speculative to assume it would have produced this evidence, bearing in mind the great lengths to which it made sense. And the Lordship will also ask you to bear in mind the failure to correct during the trial. But Lord, 2 points, 2 points are one of the ones I've just dealt with. The other one was we didn't put the request for admissions document in the trial. It's about the most disproportionate document I think I've ever seen. It's 157 sort of browbeating requests. And in fact, under the American rules, apparently you only have to answer 30. And the fact the refusal to answer it takes one absolutely nowhere. Lord, can I just say one last concluding matter on this issue before I move on? And that is this, that we do say there is a connection between our submissions, or I should say our examples in our skeleton argument on permission to appeal as to the way in which the judge approached evidence adverse to Miss Hurd. Does, we will submit, provide some support for the real danger scenario, the test which we have to satisfy? Because we say that if you look at the judgment, material of a similar type against Mr. Depp is time and again acted on, but evidence against Miss Hurd, and I particularly, Lordships will know there's a submission about contemporary documents, which is very important on the permission to appeal application. We do say that one view of this is that the judge had a very favourable starting point of Miss Hurd and really wasn't particularly interested in this adverse evidence. Lord, that obviously, I was going to develop it a bit of a separate part of it. Would your Lordship want me to go ahead and to deal with the permission to appeal, or to...
I think that makes
Lord,
sense.
thank you. Lord, again, if ever there's something this court does know about, it's the principles, and I'm not proposing to, other than to give your Lordships the obvious reference. The starting point test for permission to appeal is CPR 52.6 1A, at pages 1762 to 3, to be read with obviously the ultimate test for an appeal, when the Court of Appeal's powers to intervene, which are 52.21 3A and B. Now, Lord, I am very conscious in this position of the natural cautions which an appellate court always has about reviewing trial verdicts. If I can put it very simple language, because your Lordship should be very familiar with these concerns, there are really two. One is the judge's privileged position as having heard the witnesses and having a much closer familiarity with the evidence. And the second is a question of resource. And both those aspects are visited in the Central Bank of Ecuador against Conti Corp case, which is at tab 7 of the authorities bundle. Just give your Lordships the references. Paragraphs 5 and 6 deal with the question of resource and the privileged position of the judge. Lord, however, those principles do not apply if there is a material self-misdirection as to the fact-finding exercise. And your lordships will know that we say that there is. Can I just take you just to one case and just two?
Yes, of course. It would help me if can you formulate. You say there is a material misdirection. What are you referring to?
Lord,
How do you formulate
the judge appears to take the view that there is an inherent superiority as a matter of principle to evidence given to the witness box over contemporary documents. Now, it's perfectly true that Lord Gough's well-known observation in the Ocean Frost that contemporary documents are an essential check on credibility is not a rule of law. And your lordship will see that's referred to in one of the cases. But the contrary proposition, we say, is simply erroneous.
Yes, well, this is okay. Now I see what you're referring to. This is the proposition you get out of that paragraph
175.
175. Well, we'll wait till we get there.
Yeah,
I just wasn't sure what you were referring to when you said.
That is,
right, you wanted to refer us to.
Just one case, if I may. It's in the Authorities Bundle D at tab 9. And the only two paragraphs with this in mind, I'd ask your lordship to perhaps quickly read yourselves, if you'd be so kind. It's 48 and 49 on page 242 under the heading The Importance of Contemporary Documents. It conveniently includes Lord Justice Goff, as he then was, famous observation on the Ocean Frost.
Yes.
The first sentence of paragraph 49, and your lordships will have noticed my point about the rule of law in that sentence just above the quote from the Ocean Frost. Although this cannot be regarded as a rule of law, those documents are generally regarded as far more reliable than oral evidence of witnesses, still less their demeanour. Then the very important first sentence of 49, which is where we say this case went materially adrift. Now, Lord, we have taken 3 examples only. In this case, of course, if there was full permission, there'd no doubt be much more to say. Can I just say they overlap in this respect, these 3 examples. They all betray, on the applicant's case, an error of legal approach, we say, to the judicial fact-finding exercise. Secondly, they all relate to significant rather than peripheral issues. Thirdly, they show a disparity of approach to the evidence of Miss Heard and Mr Depp, including the treatment of their out-of-court statements, which we submit amounts to substantial unfairness.
Hang on one second.
Sorry, my Lord. Which we submit amounts to substantial unfairness. Fourthly, they all require consideration of the proper approach in law to consistent and inconsistent statements when credibility is a central issue.
Hang on one second. Prior consideration of approach to
consistent and inconsistent statements where credibility is a central issue. And fifthly, we say they support the concern that the judge was unduly influenced by Miss Heard's favour by the charity claim evidence. Lord, can I just add one postscript, a point I should have made earlier? The analysis in Meek and Fleming shows that you don't only look at the effect of this false statement at the trial when presented as true, You also look at what would the effect of the trial have been if the state to be false. And in Meek and Fleming, you'll see the court look at both. So you have to consider what would have been the effect on Ms. Heard's credibility if the untruth had been exposed. Now, Lord, the treatment of contemporary documents, there are only two examples. I'm only going to take two of the three.
Yeah.
In the yellow bundle, and I know your lordships have been kind enough to read what's on the reading list, and for that reason I am not going to go through it. But can I just remind your lordships that it's at tab 34 of the yellow bundle. This was a recording which was made consensually as a therapeutic step to try to resolve the difficulties of the relationship. The judge doesn't refer to the timing, but for your lordship's assistance, my understanding is it's September 2000, which is between incidents 10 and 11, quite late in the story, but not at the crucial is to understand that Miss Heard's position was that she was innocent of any violence against Mr. Depp, who was always the aggressor, save for, I think, one minor act which she presented as self-defense. And that is referred to by the judge, and for present purposes, we will now be in the judgment for a bit of time, so orange bundle A, please. Lordship's notes, tab 5. We gave a fairly wide number of examples, and I hope not impertinently invited your lordships to listen to a short section. But can I just, because time is short, just notice that the judge himself takes 4 examples at 171. These are all taken from this tape. And if one looks only at the last statement, just that alone, where Miss Heard says, I can't promise you that I'll be perfect. I can't promise you that I won't get physical again. God, I effing sometimes get so mad I lose it. I can effing promise you I'll do everything to change. Now, this argument, too, was heavily relied on by the applicant, both in his opening and in his closing submissions, for reasons which must be fairly obvious. If one goes back to 169, you'll see the judge summarises Miss Heard's position on the evidence. Miss Heard maintained that it had always been Mr. Depp who had been the aggressor. She said that
So sorry, where?
I'm sorry, 169, bottom of page A90,
Oh, yes, of
right
course,
at the
yep.
bottom. She said that the only occasion when she had hit his back had been in the course of incident 9, when in defence of her sister she had struck Mr. Depp. So her evidence, which the judge appears to have accepted, was that she was always the victim. Now, it's not quite a dismissal, but it's very close to, of the argument 2. It's dealt with at 175. In my view, no great weight is to be put on these alleged admissions by Ms. Heard to aggressive, violent behaviour. It's trite to say, but nonetheless true, that these conversations are quite different to evidence in court. The witness giving evidence in court does so under oath or affirmation to tell the truth, the whole truth, and nothing but the truth. Questioning can be controlled by the judge. Questions which are unclear can be rephrased. If a question is not answered, it can be pressed, subject to the court's control, and if still unanswered, may be the proper object of comment. None of these features applied to these conversations. Then there's a second reason which I'll deal with as well, which in any event, according to Ms. Heard, had a purpose or purposes different from simply conveying truthful information. Now, my lord, we put it very simply. Self-evidently, if in a contemporary, consensual, tape-recorded conversation with a clear audio and more than enough length for proper context, the alleged victim admits to assaulting the alleged perpetrator on more than one occasion, we would say several occasions on a fair view of the recording, and says that she can't promise that she won't get physical again. And when it's her case that she has never been violent to the perpetrator, such evidence requires the most careful consideration by the judge.
Just before we get to your important points about this, my understanding, I should say, having read through the whole of argument 2, or at any rate all the relevant parts, is that on a fair reading she appears to admit to 2 occasions. One, the previous night, which is in the extract just on page A91, above the hole punch, where she says, "I hit you across the face in a proper slap. I was hitting you, but I was not punching you." So that's the first thing she refers to. And then she also refers to having thrown pots and pans, and I think probably a vase,
That connects to
which
Australia.
looks like Australia, though actually if you look at the evidence about Australia, there is reference to a vase, but not to pots and pans.
Yep.
But we can be too finicky about this, but those appear to be the 2 occasions. You were saying several occasions. I'm bound to say I didn't read it that way.
Well, I'm prepared to accept 2 for present purposes, but
Obviously, your point stands whether it's 2 or
yes,
more.
but well, can I just say this? Although it's I accept your lordship's point, subject to correction behind me, that it's only 2, but it's not in a context where it can be said to be only 2. Your lordship is right that it's only 2 that she admits to, but it's not the kind of context you can say it's only happened twice is all she's accepting. But more to the point, the promise about future conduct suggests that this is not necessarily a one-off problem, if your lordship understands me. That's the last quote. Yes, and there's Mr. Sherman points out that there's a reference more generally to physical fights.
Well, it's rather complicated. They use the term fight a lot, but it's pretty clear mostly they mean what most people call a row.
Yeah. Lord, it was common ground at the trial. Your lordship's absolutely right that fight meant the American sense of a fairly heated argument. Now, my lord, first point I make is this. It's obviously true that oral evidence in court has formal characteristics which contemporary documentary evidence does not have.
Are you equating a transcript or the tape with a contemporaneous document?
No, my lord, I'm contrasting it, making the contrast the judge is drawing between oral evidence in court and a contemporary recording. And the judge says oral evidence in court is superior for the various reasons he gives. We say he's obviously right that it has some advantages over other evidence, precisely because of those formalities. But he's quite wrong, simply as a basic matter of the law of evidence, to downgrade the significance of contemporary documents, because they have themselves obvious and very important advantages, the most obvious being that their contemporaneity makes them a more potent guide to the probabilities, and also it's inherently less likely to be self-serving. And be it 2 occasions or more, it's a fundamentally important check against the reliability of Miss Heard's case that she was never an aggressor and always a victim. The judge has to, we say, go through the text of carefully, see what it amounts to, and then he doesn't do that exercise at all. Now, the second reason that the judge gives was that the recorded conversations, according to Miss Heard, and I think it's common ground that they had a therapeutic purpose. An indication of that, can I just give your lordships a reference to Miss Heard's witness statement 5, at paragraphs 5 to 6, at bundle B 17147, is where she deals with, and one of the things she says is, I didn't want to provoke him, and I'll come back to that, because there's one passage in there which is perfectly obvious that she wasn't remotely concerned about provoking him. The judge doesn't say in terms that he accepts Miss Heard's explanation or not, but insofar as the purpose was therapeutic, we have a number of submissions to make. Firstly, it's hard to imagine any therapist advising a couple to lie to each other. Secondly, on the face of the conversation, its two dominant characteristics are candour and spontaneity. If you listen, neither side is holding back, if I can put it that way. And the example that I was going to give about, she says she wasn't concerned to provoke, but if you look, just take one example at tab 34, 271, he says about, it's 5, just take the sidebars of the speakers up. He says, because you start physical fights. She says, you're such a baby, grow the F up. And he says, because you start physical fights, and she says, I did start a physical fight. And that response, you are such a baby, grow the F up, is not the statement we say of someone who is worried about provoking Mr. Depp. But it is an example of why you simply cannot, if you were doing a proper fact-finding exercise, not deal with this argument too closely. Now, my lord, there's another problem about this aspect of the evidence, which is J172, which is page A92. This is a separate recording.
Yes, just before we leave that, 176, the judge makes a reference to another recording. Isn't one of the ones we've been given, I don't think, or is it? Have I misunderstood?
No, I don't think. We haven't got that one.
No, okay, that's fine. I just wanted to check. Nor have we got, I think, the transcript of Ms. Heard's cross-examination about this conversation.
Lord, no. I mean, there's just a type problems with the limits of a permission to appeal application.
I don't...
Yeah, but your lordship's right, we don't have it. I did give your lordship the witness statement reference, so her position about it was known to your lordships.
And can I just ask one other question while I'm interrupting you? Suppose the position were that the judge ought to have found, on the basis of this conversation, that there were at least these two occasions when she had started the physical side of an altercation, which she you would say, admits. Obviously, it wouldn't follow that the judge was not entitled to find that, while that may have happened once, twice, 3 times, whatever, the general pattern was that he was the violent one and he started it. That would be a wholly unexceptionable finding, wouldn't it? You have a couple who have a stormy relationship. Generally, one of them is much more violent than the others, but occasionally she hits him. Not on her admission very hard, but still is the first person actually to hit.
Your Lordship is right. The judge could have done that. He could have done that. But what he doesn't do it at all. He doesn't. Once he starts on this road, assume for the moment, on your Lordship's hypothesis, that he disbelieves Miss Heard's "I'm only a victim" line. We don't. It's pure speculation as to where he would have ended on the other matters. But, and your Lordship, can I just mention just one example here, which I'm going to come to? There is a very, very serious allegation in the confidential judgment. I mean, very serious. If this goes to credibility, which it does plainly, not general credibility, but credibility on the primary issues, just taking that one example, we say a judge would be very uneasy about finding on the cogent evidence level once you have a witness who is plainly liable to exaggerate materially. But Lord, it's difficult. I just don't know.
No, your point, I think you would have to accept that it must be very common, perhaps most common in matrimonial cases, but in all sorts of contexts, very common for both sides to exaggerate a bit.
Yes.
And that doesn't stop the judge nevertheless reaching a finding about the problem. You're saying yes, but that on a fair reading of his judgment, the judge didn't take that approach.
No.
The judge believed every word she said,
and
didn't consider the possibility that they both might have sometimes started the fights.
It's quite simple. He didn't conduct the judicial fact-finding exercise correctly. The mere possible existence of another route is not, with great respect, a reason for simply excluding this complaint.
Yeah. Okay.
Well,
I don't want to slow you down.
No,
but it's an important point.
Can I just deal with another? But this is another important one at 172, and this is even more unsatisfactory. This is supplemental bundle 35, which is the next recording. It's only an extract. Now, this does tie in directly to incident 13. Which is just before she goes to a music concert at Coachella. Now, what the court needs to understand about this recording, it's got a completely different background. Miss Heard had obtained a restraining order against Mr. Depp, and there was, after the restraining order, a meeting in a hotel room, which I understand she initiated, and she recorded this meeting without Mr. Depp knowing. And at the top punch hole, Mr. Depp says this. This is directly about incident 13. I don't want a divorce. I never want a effing divorce. I never want a divorce. I didn't want you to effing go to Coachella without effing talking to me because I left you because you were effing. You effing haymakered me. You came round to the bed to effing start punching on me. Now, she, unbeknownst to him, is recording this conversation. There is no denial by her of that. And the obvious inference is she knew if she denied it that he'd have persisted. Now, the judge simply wraps up this recording at 172 with his general treatment of the matter at 175. But this recording has a completely different Genesis. He does refer, if one goes to 466, when he's dealing with incident 13, paragraph 466, A148, he refers to Mr. Depp's account in evidence, which, broadly speaking, reflects what the transcript says. But then at 4.6 Roman 5, and this is where the same paragraph 476 Roman 5, page A150, he says this: I don't accept that Miss Heard assaulted Mr. Depp on the 21st of April. And then he says this: I have explained already why my view on this remains the same, notwithstanding the recorded conversation in San Francisco in July 2016. Now, Lord, complaint 2, I'm going to try and take very shortly because of time, is a very important complaint. It's about the most serious finding in the confidential schedule. There are two incidents. One relates, in the confidential schedule, one relates to an incident at Hicksville in June 2013, which he rejects. Hicksville didn't appear in the open or the closed incident version of the first version of the defence formulated with Miss Heard's assistance, and it only was added by re-amendment on the 6th of March, shortly before the first scheduled trial. And the judge addresses that incident at paragraphs 3 to 7 of his confidential judgment at tab, same tab, please, at 182 to 183. And I obviously have to do this by reference to the text. The allegation is in paragraph 6. His reasons for rejecting it in paragraph 7 include its lateness. Secondly, a specific point in the second sentence of paragraph 7. And thirdly, a reference to a conversation with her acting coach, Miss Sexton. Now, I acknowledge there's a difference between not accepting and rejecting, and it's not wholly clear. It's clear from paragraph 8 that he's satisfied that the standard of proof is not discharged in relation to this incident. But we say, having regard to the extreme gravity of the other incident which he does find proved, he has to consider his reasons for rejecting the first incident. Now, there's an additional problem, we say, with this second incident. And Lord,
So your point essentially is that, though not in detail, in terms of overall approach, the reasons given for not accepting the first incident applied equally to the second.
Yes, Lord, pretty much more elegantly, exactly. Lord, the second point is this, that if one looks at the reasoning in relation to the second incident, he appears to apply particular weight to a conversation with Miss Sexton, who was the acting coach. Now, this conversation is 3 years after the event. Now, Lord, I'm absolutely aware that modern courts don't require prompt complaint anymore as an ingredient for this kind of offence. I don't want to be understood to be insensitive to the delicate issues which arise. But this is after she has been sued in America. It's after her first version of the amended defence has gone in June 2019. It's a conversation in August 2019, and the judge appears to give particular weight to it at paragraph 16. And not only do we say that it really cannot deserve that kind of weight, but that the opinion of the confidant as to whether Miss Sexton was telling the truth is wholly inadmissible. And this cannot simply be dismissed as one of a number of incidents. This is so grave, this finding, that to have regard to the impression it made on a third party whom she told over 3 years later at paragraph 16, we do say really is a material misdirection. It's wholly irrelevant what the opinion was of the person she told. Lord, I'm accelerating fast to try to...
Yeah, you're doing very well.
Yeah. Lord, lastly, can I come to the treatment of incident 2?
Sorry, just before you leave
Lord,
that last one.
Yes.
Sensitive to the fact it's in a confidential schedule. Where do you say the judge accepted? He refers to the fact that the third party
Yes.
believed it to be true, but that doesn't appear to form part of his reasoning for accepting it.
Well, Lord,
Or am I wrong on that?
no, well, your Lordship is right that he shouldn't, with great respect to him, really be referring to the confidant's understanding at all. It's relevant at all, it's simply a complaint. But he plainly relies on the Sexton conversation in paragraph 17 early on.
I understand that, but
Your Lordship is correct. He doesn't in paragraph 17 go back to it, that is right.
sorry to interrupt.
Well, not at all. Can I also just say this? I'm not suggesting that the other matters in paragraph 17 are irrelevant, but they are very light evidence that an assault of this nature occurred. And we make other points about the absence of other kinds of evidence in our skeleton argument, which the court won't need me to mention. They're fairly obvious. Now, my Lord, the last one, can I take it pretty briefly? The incident 2 was presented in the first witness statement. That's the supplemental bundle yellow, please. Miss Heard's first witness statement at tab 3, at page 36. At paragraph 54, as being a startling new incident. This is not a confidential judgment. This is an open incident. It was really out of the blue. I didn't have much familiarity with this kind of crazy behaviour at the time. And then again at 64, on page 38, this incident was unlike anything I'd experienced with him until that point. I didn't realise that it was a sign of what was to come. Nothing wrong with that evidence. It has a certain vivid quality. I remember this particularly well because it was the first time that anything of this kind of seriousness happened. Now, the court will know it's a fundamental rule of defamation since the 19th century, now in the rules, that you have to plead. The old wording was with the particularity of an indictment. The new wording is all facts and matters relied on to support your case of truth. It's in the CPR practice direction at part 53, paragraph 4.3. Now, right the way through, including at the trial, only one incident was relied on in March. There were issues, as your lordship would have seen, about the date. It started off at the 8th of March, and then it ends up being moved to the 23rd of March.
Yes, well, we followed all that through.
And
Yeah.
only one incident in March was put to Mr Depp in cross-examination. Now, the trial started on the 7th of July. On the 26th of June, 10 days before the trial, Miss Heard tied this painting incident to a text about a long drama on the 10th of March. On the 4th of July, 3 days before the trial, she performed a volte-face, and it was no longer a specific incident. It was a spate of assaults in March, and I got confused about the dates, and that's why I couldn't got the date wrong before. Now, this many occasions in March was not adopted by the defendant, was not pleaded as many occasions. Only one occasion was put to Mr Depp. And in closing, Mr Depp's counsel put in a document on inconsistency, which is at supplemental bundle tab 2, and I'm not going to trouble the lordship with it. Now, what the judge does, going back to his judgment, please, core bundle tab 5, at page 103, and this is an example of simply accepting a complete departure from the previous case. It starts at I'm sorry, I think I said Roman 7, it's Roman 8. Bottom of page 102, Mr Sherman submitted it was significant that Miss Heard had originally given a different date for incident 2, and that she and her sister had been caught out in a lie, which had led them to change their story and split incident 2 into 2 separate incidents, and so on. I was not persuaded by this submission. I accept Miss Heard's explanation for how she originally came to give the date of 8th of March. Miss Heard said that Mr Depp inflicted a number of assaults on her in March 2013. Only one is pleaded, but I accept that is why in some respects Miss Heard's account was confused. Now, he doesn't consider at all her original evidence that this incident stood out in March as the first time anything of this gravity had happened. Only one assault had been put to Mr Depp in cross-examination. No details of the other alleged assaults had been given. And we say this is fundamentally unfair. Now, Lord, I hope your lordships understand why with these 3 examples I do say they all have an element of a thread, that Miss Heard's evidence is simply accepted, if I may put it, not rudely, too glibly, without proper forensic examination of the inherent probabilities and the contemporary documents.
And although it doesn't need saying, we appreciate the skeleton argument. There are other examples, but you've appropriately chosen the most
Lord,
part.
one has to be selective at this stage.
Yes.
Lord, can I lastly just say this for clarity? We acknowledge this court is in absolutely no position to decide whether these allegations are true or false. And if I may just take, hypothetically, the optimist view that we got permission and there was a full appeal and we succeeded, the only relief that we seek is a retrial, because plainly these would have to be re-examined, but we say they should be in this exceptional case and by a proper fact-finding judicial exercise where the fresh evidence would be part of the exercise. Lord, I'm very grateful.
No, thank you. We will just take a short time to consider where we go from here. Thank you very much.
All rise.